You got it.
Yes, ma'am. Can you see it?
Yeah. Can we enlarge it if we have to?
Mm-hmm.
Is it going to get the sound?
They're gonna speak in the
The mic.
microphone,
Okay.
or I can do a better camera view.
It has. She was talking with someone else who helped her, maybe from her office, and she's got an alternate way. I was trying to get it to Jamar and answer her main line, but I couldn't let that. She just now got up with you. So. Yes. Yes. Thank you. Right,
Okay.
ready?
Yes, ma'am.
Is that recording?
Yes, it's live now.
Okay, it's live.
Call the meeting of the Moore County Board of Elections back into session. We were temporarily in recess pending the resolution of a technical difficulty that temporarily prevented our streaming and recording this meeting. Now that that's been resolved, we will proceed with the preliminary consideration of protests filed by Mr. Jefferson Griffin, and actually that's the one statewide that applies to Moore County. And I will defer to Ms. Dixon.
Great.
Or Ms.
Let me make sure, is this working? Okay. And everyone, please make sure you speak into the microphone because we are, or were having difficulties with our technology tonight. So this is a preliminary consideration for a protest regarding Judge Griffin's, some of the petitions he has submitted. And Tawana, you'll have to go over that. I didn't bring that with me. I have it if I need to on my computer, but did you want to go over each protest? Please do, and then we'll go through the outline.
So Mr. Griffin brought before the County Board of Elections of Moore County two types of protests. One protest that he brought before us was a protest of votes for those who were felons. And then another protest that was for consideration was a protest of votes that was of those who were deceased voters.
Okay. Great. And just for the record, how many were on the protests for felons? Okay, so can you state the name and into the record?
So for the record, the actual felon protest that was an actual verified for Moore County was actually one, and that name was Justin Edward Crisco.
Okay, I don't need to know what you verified, I just need to know what they protested.
For the felon list was that name for Edwin Justin Crisco.
One was
One
another.
name.
No, there were two names.
Not verified. Okay. The second name was Kenneth Harris Moore Jr.
Okay, so that was a protest submitted with two names. Okay, and it was protesting a felon record in voting.
Correct.
By those people.
Yes, ma'am.
Okay. And what about your other protest? Can you just describe it and read through it, please?
This protest was for deceased voters that had, Mr. Griffin was protesting that 6 deceased voters had voted.
Read their names out.
The names were Wilma Baldwin Thompson, Dorothy Wyatt Bunch, Beverly Slater Raphael, Roberta Von Willer Taylor, Charles Knox Martin III, and Sajoni Scythe Gandhi were the deceased voters that Mr. Griffin was protesting.
So that's 6 total.
Correct, yes, ma'am. And these were voters through absentees votes, and for the felons, it was votes through early voting votes that he was protesting.
Okay.
Are those all the protests you received that fall under the County Board of Elections jurisdiction?
Yes, ma'am.
So one of the considerations, there are many, and if you want Tawana to read out, and this is directly from the voters, North Carolina State Board of Election Protest Procedures Guide. This whole process, I don't know if you all have read that on page 6. If you all have, we have it here, and we'll not read it for you. Okay? So one of the considerations, as Tawana has outlined for you, is was the protest, or in this case, there's multiple protests, were they timely filed? Tawana, can you answer as to whether or not they were timely filed? Let me first go over what this law says about being timely filed. Administrative Code 08 NCAC 02.0110, subsection B, states the county board shall not consider election protests not timely filed, but shall refer in the same manner and within the same time period provided in paragraph A of this rule, all such untimely protests along with the copies of the protest and attachments to the state board office for consideration under GS 163-182.12. For the purposes of this rule, timely means within the time specified in GS 163-182.9. And if we refer to the statute 163-182.9, it states in subsection B, it discusses the timeliness. B4, the timing for filing a protest shall be as follows. And there's an A, B, C, and D. Subsection A discusses if the protest concerns the matter in which votes were counted or results tabulated. So that's not my understanding of what we're here for. Subsection B, if the protest concerns the matter in which votes were counted or results tabulated, and the protest states for good cause for a delay, the protest may be filed until 5. But again, this protest is not about votes being counted or results tabulated. And subsection C is the one we believe is applicable. If the protest concerns an irregularity other than vote counting or result tabulation, the protest shall be filed no later than 5 p.m. on the second business day after the county board has completed its canvass and declared the results. So,
Ms. Leland, would you no later than 5 p.m. on the second business day following canvass and
yes,
certification? Okay.
yes, that's what the statute says. So, when was your canvass? What date?
Canvass was November the 15th at 11 o'clock that morning.
November 15th at 11 o'clock.
Yes, ma'am. And we completed it at 5 o'clock that evening,
Okay, and what day was that on?
a Friday.
A Friday. And so the next 2 business days would be when?
The 19th of November.
So that's Tuesday the 19th.
Yes, ma'am.
And when did you receive his petition?
At 5 o'clock 501 to be exact, 501.
Okay, that's the email.
Yes, ma'am, that's the email that I received.
Is that how it arrived?
Yes,
Is that how all the petitions arrived?
yes.
Okay, can you just share the email and just read it so everyone can see it? I think you brought copies for everyone.
Yes, ma'am. So it's from the North Carolina GOP Legal, sent Tuesday, November the 19th at 2024 at 5:01 6 seconds PM to the State Board of Elections, Moore County, NC.gov. And it also has the CC of C. Shower, Dowling Firm, the Moore Griffin election protest. On behalf of the Jefferson Griffin, please find attached the corresponding elections protest. Should you have any questions or require further information, please feel free to contact Greg Schwarsher, CC Counsel for Jefferson Griffin at cschwarsher.dowlingfirm.com. Thank you for your attention to this matter. Best regard, the NC GOP legal team.
And is anyone here for Judge Griffin?
Yes.
And are you an attorney?
Yes, ma'am. Attorney Will Taylor.
Okay, thanks, Will. Okay, so let's just pause, and I don't know if the mic's picking me up. Do you all have that email? If not, could you pass that out to them so they can see it? You did, okay. You all see that? It came in at 5:01. Do you all agree that that was 2 business days past when you canvassed? She said you canvassed Friday, the 15th, November 15th, and it came in, so then that would be Saturday and Sunday, that's not a business day. So then Monday, Tuesday, it was due Tuesday before 5 according to the statute. Came in at 5:01 and 6 seconds. So under this circumstance, the state board has prepared guidance, and it's entitled FAQs for the Griffin election protest. If you don't have it, please ask us and we'll share it with anyone. Question 5 reads, what should my county board do with a protest that was not timely filed, i.e. received by 5 p.m. on Tuesday? It says, the answer, your board must determine whether the protest was timely filed. If it is determined it was not timely filed, then the county board cannot proceed on the protest and must instead refer the matter to the state board. C 08 NCAC 2.0110B. That was the first regulation I read to you tonight. It goes on to say, if a protester, if a protester provides argument or evidence at preliminary consideration that the protest was timely filed, your board should consider that. So I'll defer now to Judge Griffin's attorney.
Thank you, ma'am.
I have a quick question.
Yes.
Did that protest have to be filed with all 100 counties, or was it filed with the state board of elections, and then we would be notified that it occurred? Because I think that makes a difference. It was filed with the state. It might have been before 5 o'clock. We didn't get a notification until 5:01, but does it have to be filed independently with all 100 or with the state, and then the state would let us know?
This is, so this guidance is for all 100 counties. The protest has to be filed with the counties that the counties have jurisdiction over. And I'm sorry, I forgot your name.
Attorney Will Taylor.
Will Taylor, did you want to be heard on that?
I would love to be.
Okay, do you want to come get in the mic? And I apologize, we don't have
Sure.
better mics for
No,
you.
that's
I'll be
fine.
happy to move and let you sit here.
And thank you all very much for having me here tonight. My name is Will Taylor. I'm a lawyer in private practice from Stanley County. I also do a lot of cases here in Moore County. Always love coming over here.
Could you move up to the mic?
You know, I just have such a loud voice. I just kind of figure I can talk from anywhere. But yes, I'm from Stanley County. I'm in private practice there, but I work all over the state, including sometimes here in Moore County, and am here representing Judge Griffin's campaign. And the other lawyers in Raleigh are saying they're about to send me an email showing that the protest was transmitted before 5. I realize that, even though we may be living in the year 2024, even though we may feel like we're in a time of instantaneous communication, sometimes hitting send and then having an email or other submission pop up on the other end is not instantaneous. It doesn't take a few seconds, even sometimes it can take a couple of minutes. And I've noticed as the years have gone by that problem has gotten worse and worse. And so my understanding is that the Griffin campaign did submit this before 5 p.m. It may just not have appeared until 5:01 here at the Moore County Board of Elections. The other thing that I'll point out is that the statute requires substantial compliance. There is no harm suffered by anyone from a protest arriving 1 minute late, if in fact it was filed late, which again is not something that the campaign concedes. But if a protest did in fact show up 1 minute late, this does not change the governance of our state. This does not overturn the administration of justice. It's just that it hit 1 month later. And okay, let's see here. I've just received an email from the state party. Thank you for bearing with me. It says it has some other information.
Do you need to take a minute and look at that?
Just a moment. Let's see.
There's another chair over there if you want to.
Okay, thanks.
Okay, so I have an affidavit by Attorney Kyle Offerman with the State Republican Party stating that these protests were sent out to all 100 county boards of election across the state before 5 p.m. I am happy to forward that to you, ma'am, or do whatever else it would take to share that.
That would be fine. Can I have the mic?
Yes, ma'am.
Please do send it to me.
And what is the best email address?
MissDeedley1@moorecountyNC.gov.
Okay.
Hello, can y'all hear me? Is it on?
Yep.
Yeah,
Okay,
it's
it
on.
just doesn't, I can't hear it. So let me address a couple of points real quick, just regarding the law. We did reach out, and I know the director, Tawana Dixon, reached out to the general counsel, Paul Cox, multiple days ago regarding this issue. I called his cell phone today and left him a message as well regarding this issue. And I want to say a few things, and if we need to, we can recess it. But let me just make sure I make some points of the law. The statute says shall be filed no later than 5 p.m. I know and some, practically thinking you might say, well, 1 minute, what's the big deal? I get that. Except I've been doing local government law for over 20 years, and there are instances like our bidding. We can't accept any bid 1 second past the deadline, period. That's in the law. We have to throw it out. It doesn't matter what the excuse is. So I'm not sure if this is one of those situations, it looks like it is to me, I'm willing to defer to the state board general counsel for further guidance. And that might be the best thing because we want to do it correctly. I know we're coming up on Thanksgiving. We do have a tight deadline because if we do move on to hearing, we need to do that within a particular timeline. And right now, we would be looking at, I think, no later than December 2nd, if I'm not mistaken. So I would recommend either, I will look at what he has sent me, but I mean, you know, when I file something at the clerk's office, it has a timestamp on it. And, you know, the timestamp actually matters. So all I'm here to do is make sure that we are in compliance with the law. Regardless, it gets deferred to the state board. That means they will consider this matter and not you all. And I'll just stop right there. Do you all have any comments or thoughts?
I have a question. I'm trying to understand the procedure for a candidate for statewide office to file a protest. I would have assumed it would be with the State Board of Elections instead of sending it out to all 100 counties. Maybe that is it. I just would have thought the state would have been involved at some point in time. Now, you also said, Counselor, that there is an email trail that shows it was transmitted prior to 5 o'clock.
Sir, what I have is an affidavit from Attorney Kyle Offerman with the State Republican Party stating that it was filed before 5 o'clock. And I think logically speaking, if it arrived here at 5:01, that is evidence for the fact that it was filed before 5, because typically emails take a couple of minutes to show up. And it got here at 5:01, probably was filed at 4:58, 4:59.
So I'm still trying to understand that they do not need to file a protest with the state. They go straight to the counties. Is that true?
That is my understanding, yes, sir.
That's I'm looking at the order, and Ms. Leland, you have this as well. It looks to me that there is a separate document. This accompanied the email that we received last week that began with basically a cover letter from the attorney's office representing Mr. Griffin's campaign. Next thing, I believe, logically or chronologically, was this filing, which looks to me like what Mr. Carpenter is asking about, a protest that's filed with the state, at which point this might be obvious to everybody already, but my understanding reading of this is that Mr. Griffin challenged or submitted a protest to the state based on challenges to those 4 categories of voters, not only the 2 that you asked Ms. Dixon about earlier for Moore County. And then the state affirms that the state board would take over consideration of 2 of those categories, the other 2 categories.
That's right. They have taken jurisdiction over those other protests.
Yes, ma'am.
That they also filed here. That's correct.
So then is the state acknowledging that it came in prior to 5 o'clock? Otherwise, I would think they would say.
No, sir, there's not.
And sir, one thing that I will say, I'm reviewing the statute 163-182.9 on filing an election protest. Thank you, man. And so it says that the protest shall be filed no later than 5 p.m. on the 2nd business day after the completion of the canvass. Well, what does it mean to file something? I would argue that clicking the send button is what constitutes filing. If someone walks into a courthouse and hands over and puts a filing on the desk of the clerk of court at 4:59, and then the clerk doesn't get around to picking it up until 5:01, that is out of the control of the person who provided that submission. That, we know that emails typically take a couple of minutes to show up. If it got here by 5:01, that strongly suggests that send was clicked around 4:58, 4:59 before 5 o'clock, and thus timely.
A copy of the sent message should instantaneously say the time that it went out. I mean, when I send something out and I look on the sent side, it's going to be there and it's going to say when I transmitted it. And like you say, it may take time before it actually gets to somebody, but I would assume a copy of the message that was sent out or the email that was sent out would show the time that was actually transmitted.
Seems to me that the email is in the email header. It is in the sent line that the date, the time 5:01:06 is specified. That it was sent at 5:01. There's not an email category, at least in this system that I can see, that says that Ms. Dixon's office received it at 5:01:06.
Well, I have this exact question that I wanted to ask Misty. In the legal world, when you talk about a deadline for filing, I believe you mean a deadline for receipt, not a deadline for when it was sent.
That's my interpretation. Again, I'm willing to defer and get an opinion from the general counsel. I want it to be correct, but that's my understanding of the law. And I'll say I've been practicing for 23 years in local government. There's many things in the statute that we deal with that has these hard and fast deadlines. And I understand, and as a practical matter, it seems like you could say, oh, it's just 1 minute and 6 seconds. And I mean, in this instance, it does appear that if the board does determine it wasn't timely filed, then it does get deferred to the state board. It doesn't just go away. So I don't know. Either way, we're prepared to have the hearing tonight. Again, we just want to do things absolutely correctly. It does say shall. And, I don't know. Again, I'm willing to defer to the general counsel for the state board. Are you?
Well, one other thing that I'll say, in the next part of the statute, 163-182.10, section A1, preliminary consideration, it says the county board shall, as soon as possible after the protest is filed, meet to determine whether the protest substantially complies with General Statute 163-182.9, the one that we were just talking about. Basically, what this is.
Can you talk into the mic, please?
Yes, ma'am. So basically, the next piece of the statute, 163-182.10, says the county board shall meet to determine whether the protest substantially complies with the statute. And so that word substantially is very important here. It's not saying on a technical basis was every single thing exactly right. It's saying in terms of its general substance, was the protest done properly? And one way that courts will evaluate that question of whether something is substantially done is they'll look at what are the effects. If this was a protest that was filed 1 year after the election, then obviously it would not substantially meet the requirements. If it was in fact filed 1 minute late, that doesn't have any practical effect on the situation. Justice is not somehow being denied if someone is 1 minute late in doing something.
Mr. Taylor,
Can I interject? I was just checking my sent mail. My sent mail has a timestamp on there. Could you do you have your sent mail?
I was not the one that sent it, but
Was it attached to his affidavit? I haven't looked at that.
It wasn't. They were just, the people at the state party were just texting me that they had forwarded something
Okay.
else, which I'm looking for.
I'd like to address the comments that you just made. The issue of whether it was timely filed is not supposed to be examined in terms of substantially. That's whether the protest itself meets the requirements of the form of a protest. It's not the timeliness.
There are two different items that, and I believe that the agenda that Ms. Dixon prepared is quoting from the guidance. This is along with what Ms. Powell is saying. First one is, was it timely filed? That's what we're talking about now. And I totally, as an ordinary guy, sympathize with your point about justice was not deserved, and this is not going to derail the train of state. But the substantial criterion has to do with the overall form requirement. And then there's a third matter that has to do with probable cause.
Well, sir, with all due respect, the statute says that the question is that you're here trying to determine is whether the protest substantially complies. And part of that protest is the time at which it was filed. And if it was in fact filed at 5:01, that is substantial compliance with the requirement in that statute of filing at 5 o'clock.
I have a
What
feeling
time,
that
what time would not be substantial? Yeah.
That's a good question. It's somewhat of a judgment call. I mean, maybe it's an hour, maybe it's a day. I don't know, but I know that 1 minute is substantial compliance.
Let me read, so the administrative code 08 NCACO 2.0110 subsection B states that the county board shall not consider election protests not timely filed, but shall refer in the same manner and within the same time period provided in paragraph A of this rule, all such untimely protests along with copies of the protest and attachments to the state board office for consideration under GS 163-182.12. For the purposes of this rule, timely means within the time specified in GS 163-182.9. 182.9 specifically states that it says it shall be filed before 5, no later than 5 p.m. So I think with those multiple, at the administrative code, you have the statute saying it, and I'll say the state board guidance says you cannot proceed with the protest if it's not timely filed, and it will be deferred to them. They will take jurisdiction of this matter. If we want to wait and see if and I have texted while we have been talking again, because I understand the importance of it, the general counsel for the state board, Paul Cox, to ask him to please weigh in on this, what the definition of filing means. But I think I'm correct, and we're just trying to do it correctly. Do you think that Judge Griffin would lose out in this matter if it gets deferred to the state board? What's your thoughts on that?
The state board, of course, is an unelected body. The legislature, an elected body, of course, makes the laws in question, as we all know. The state board exists as sort of a backstop to what the county board is doing here. If this is immediately deferred to the state board, then Judge Griffin has lost the opportunity to have a hearing here at the county level. What would happen at the state level? Well, we don't know. That could be any number of different things, but that's intended as a backup for what happens at the level of the county board. And if this is immediately kicked to the state board because of a discrepancy over 1 minute, then part of the opportunity to be heard on these different issues has already been lost.
Madam Director, if somebody filed for office and they were 1 minute late past the filing deadline, would you be able to accept their filing for office?
I'm sorry, could you speak into just I apologize. I wish it's not even my equipment, and I apologize.
No, sir. And I was gonna mention that fact. So when we have any set time frame, even if it's election day and we say polls close at 7:30, and if you're not in line and we don't block, if you're not there by the time we have that set time frame, we cannot accept. So if you're a candidate and 12 noon is the deadline, and if you're not here in this back part of the section with your number at 12 noon and 12 noon hits and you're trying to come through the front door, we cannot accept. We can't take you as a candidate because we have set times that we have to take you. We can't do it.
Okay, then my next question is going to be, this email was sent out to all 100 counties. We received it at 5:01:06.
No, it was sent.
Well, it
says sent.
so my guess is, did all 100 counties, does their email say exactly the same thing?
No, so we received it at that time that you see. I sent it to the state board and I said that this doesn't seem timely. Because by this time, there was a chain, it was like a chain reaction. Some counties were just receiving the protest at 4:30. I hadn't received mine yet. By the time I left this office at 5 o'clock, I did not receive the protest yet when I left here at 5 o'clock.
So that's my question. Did any county receive it before 5 o'clock? Did any county receive?
Well, she just said
Didn't
something.
you just say that?
Yeah, there were some counties.
Well,
But
then,
there were some counties that did start receiving it, but like I
Who are
said,
the counties that are-
I'm aware of Mecklenburg, I'm aware of Rowan County, but there were more counties to the west of me that received it first. I hadn't received it yet. When the first county notified me that they had received it, I asked them, I said, how did you receive it? I said, did you receive it by mail or did you receive it by email? And she said they received it by email. I said, okay. So I stayed and I lingered. By the time I left here at 5 o'clock that day, I had not received it.
okay, I'm just trying to figure out, was the transmitted at the same time? Was that a mass sale, send out? And this is basically asking the lawyer. I would assume when I send something out to a lot of people, it goes to everybody at the same time. And I find it hard to believe that you'd send out some at 4:30 to some counties, and then 4:40 to some other counties, and then 5:01 to some other counties. So I'd like to know, did all 100 emails go out at the same time? If they did, and some people got them early, then I would say there's a problem with the email system. If they did not go out all at the same time, then, that's kind of a problem within the protest. You should have done them all at the same time at that 4:30, which you obviously sent some of them out. So I'm just trying to understand, did they all go out at the same time or did they go out piecemeal?
I do not know. I was not involved in that. That's an excellent question, and I'll certainly ask the state party now by text.
Based on what I can infer, again, from the heading on the email that is copying us today. And I'll go from the top, because what Mr. Carpenter says about who is it sent to, is it a mass email? And it looks like it's to individual counties. It's from the NCGOP legal department address, sent on Tuesday, November 19th, 2024, 5:01:06 p.m. That's sent to Board of Elections that's elections@moorecounty.nc.gov, with copies to C. Shower at Dowling Firm. And that's it. And the subject is the Moore Griffin election protest. Based on that, and there could be some other stuff going on behind the hood that I can't see by looking at a piece of paper, that it is.
It's individual. If you've read the protest, they're very specific to the counties.
Because they have attachments that are specific.
Yes, very specific.
So they had to send individual ones.
Yes.
Yes. So some counties might have received it in a timely fashion, and it looks like we did not. And it's not like it's not going to be considered, that it will be referred to the state board.
One of my concerns about sending it to the state board, and I see this in court cases where something is decided incorrectly and then gets appealed to another court, it's got the stench of a negative decision on it. And, you know, I've seen this many times where a client of mine has a good case, a judge decides against the client, and then the client appeals it, and the next judge who looks at it says, oh, I see the last judge decided against you. It's a similar principle here. If this is tossed out and it's taken to the state board, the opinion of the state board is still colored by the decision that the local board makes. Again, you know, we've talked about a lot of different things involving election law, but what I'll just remind you of is what I said earlier, that the statute in talking about this specific act of filing a protest talks about substantial compliance. Now, in the act of filing for office or the act of voting, the rules might be different, but when it comes to filing a protest, 182.10 says that it's a matter of substantial compliance.
I'll just say this. I'll preface it by saying, at the risk of sharing personal information, not embarrassing personal information, but I'm not interested in trying to get out of the responsibilities or work or another meeting by this Board of Elections. We're in that groove since before elections and following elections, and I spent hours since over the weekend trying to understand what the requirements were and preparing for this meeting and preparing for the hearing subsequent to this, based on what we decide whether we can advance it. And I think that I'm kind of committed to the process, but I think that it's kind of like a flow chart, which I think also could protect Mr. Griffin's case from being tainted when it gets to the state level, because we come down to the first decision point, and it's that, is it timely filed? If it's yes, then you go on to the substance of it, which we haven't even approached. If it says no, then we say, we will send it to the state. And you may know, or Ms. Leland may know, is there a provision at the state Board of Elections level for them to say, reasoning along the lines of Mr. Taylor's, hey, y'all, this is close enough for substantial compliance, so we believe that you really do need to consider this. Do you know if that's a possibility, a possible response from the state if we say we don't believe we can address it at Moore County because it's not timely filed, we're kicking it to you?
And is your question whether or not the state board will consider their case, or?
No, ma'am. I think it says that they would, but it is one of their options to send it back to us. In other words,
Not that I've read.
Okay.
I just want to address something. I take exception, and respectfully so, to, and I'm sorry, I'm terrible at names. Will Taylor's, and because I didn't want to call you opposing counsel, I don't feel like you're opposing. But Mr. Taylor, Attorney Taylor's opinion, but you know, there's no stench here. I don't like that word at all. That reminds me of many years ago, I did criminal defense, and you know, you may lose in district court representing your defendant, and maybe you could say there may be a stench there when you appeal it to superior court, because you already lost one time. But there's no stench here. This is a strict compliance, statutory and administrative code that we have to look at and almost check the box. The substantial compliance substantially, or whatever that phrase was. What was it now? My mind just substantial compliance. That is for the probable cause element. So you have multiple laws stating that it has to be in compliance with 163A-182.9. And again, if you want to defer and wait for Paul Cox, I'm more than happy to do so. And we can recess.
One thing I will say, I was just sent a screenshot from the state party of a copy of this email, which was sent at 4:59. According to their records. I'm happy to show this to the county attorney.
Is that to Moore County?
That's right.
Let's see.
notice. It says more Griffin election protests than 459.
Do you mind if
And I'm happy to
just let me
forward
take
it
my
to you.
glasses
Sure.
It's really tiny little writing.
I would have needed my glasses.
Actually, this is so blurred out. I believe you, but it's very blurry as to,
If it would help, I would be happy to show the individual board members.
yes,
my
could
phone.
you forward that to me?
I will now. What's
Are you sure that's a screenshot or is that a PDF?
I believe it's a screenshot.
Okay.
And what's your phone number, man?
Send it to my email, Misty Leland at moorecounty.nc.gov. Yes, could you print it?
That's what I'm. See if I can send it to you so you can see it.
And if the board members would like, I'm happy to approach and show you my phone.
I'd like to print it, but show them the phone also if you want to.
Sure,
Did you send it to me?
I did.
Okay, I haven't got it yet.
So it says more Griffin election protests. And then it says 459.
Who's the second one?
Here, can you,
More Griffin election protests.
it's very good. Here, I'll send it to you. Print it out.
Why would it say-
I would say 459 or something. And it says sent at 5:01. I can't see it on there.
Let me see if I can find it.
I'm gonna send it to Tawana. She's having trouble like I am
I
trying to
can't
see
see
it.
that.
Well, from the point of view of right from the point of view of the sender, the label sent is not, isn't part of the heading.
Mhm.
It's just got it's got that time and date.
When was it sent?
Well, it looks from here, that it was just. I'm just continuing the substance of the email. So just since we're being picky, the email that we're looking at on the phone is the same as the email that we received. So from Tawana's computer's perspective, it thinks that the email was sent at 5:01, and from the perspective of GOP's legal team, it looks they're being told that it was sent at 6:59. So you're out.
Or 459.
4:59. I'm sorry. I don't know. Thank you.
Yes, sir.
Don't know what it's actually. Oh,
Yeah, I do. I'm just gonna check something else on mine here too.
So it says more Griffin election protests, and then it says 459.
Okay, this went to board, where? Who board? I'm trying to see who the two is dear director. So which board did it go to?
This was the one to Moore County.
is that clear in the two line? I mean, I think
That says, yeah, it should, it doesn't,
Should
it's
say
got something
elections
else.
at Moore County.
CSCH,
that's the copy too.
it just says to board.
Oh,
I'm trying to figure out which board it's going to.
And
Okay.
that's just a
And that guy-
screenshot, so it may not.
It doesn't show that it's our board. It's not gonna be.
I guess is it possible that he sent it? Is that 2C Shower, or is it copied to
See,
Shower?
it should look like this. To the Board of elections at Moore County.
Yeah.
You see that?
Yeah.
You don't see that?
No, I don't.
That's what we see on this one.
Is it possible
that's
that
what
he
I
sent
Yeah.
one copy of the email that included the content that he was going to send to Moore County, and that's what we're looking at on the phone, and then he having given it to, I don't know if that's Mr. or Ms. Shower, and then sent it to Moore County Board of Elections and copied it to C. Shower.
There is a wide range of possibilities.
I'm just,
What I'll say is that
I don't even see a timeline. It's weird.
so
You gotta scroll way over.
So, the timestamp is right there for you. So what I'll say,
This does not say it came to the Moore County Board then.
And when I get something from Tawana, like I got something that says today at 10:25. And what they told me, I received it at 10:25 today. Now, when I look at this, even though it says sent, I never get anything as sent. At least when I,
We just said that.
because you printed this off of yours, right, Tawana?
Yeah,
Well, then that would be Tawana having sent it
no,
that's
from up here, because she said from Tawana to the help desk. Said
But
that-
if you come from
That's
the
when-
Keep going
elections
down.
board, you will see election at Moore County.
Yeah.
Board. I don't know whose board that represents on that.
this doesn't indicate at all that it's the one they sent you.
Exactly. This could
It
be-
just
could
says
be
board.
Their board. It could be the NCG.
Right, we don't
I
know.
don't know whose
Without
board
that.
is.
Yeah,
email, you can't look beneath the name board to see what the email address is.
yeah, because we can't do that.
Yeah, Marty, can I see the printout?
So it appears that basically some of the counties, and I don't know how many, received it before the 5 o'clock, so that they will be able to move forward at that point in time.
I'm sorry, Sarah, what?
It appears that several or many counties in the state received it prior to 5 o'clock. You've said some got it at 4:30, which means that those counties will be able to move forward with this because they received it in a timely manner. I guess I'm kind of a stickler too, 5 o'clock is 5 o'clock, or whatever, they say that's your time, that's your time. So it appears that they're going to be able to have this protest in some counties, but maybe not in all. Do we know how many other counties did not get it at 5 o'clock or get it by 5? I'm just kind of curious, how many counties are actually going to be involved in this protest now?
But that's really irrelevant.
It's-
But I'm still kind of curious.
Sure, but listen,
It has nothing to do with our decision.
Well, because there could be a comment somewhere along the line at the state level that it was sent out, some were sent out at 4:30, and they may argue that the intent was there. And even those others received it after the 5 o'clock, that the intent was that it went out at before 5 o'clock.
what I'll say that sometimes you see the wisdom of why laws were written a certain way. And I think this whole evening of conversation that we've been having is kind of proof of why that word substantial was thrown in there. I don't think that the state legislature intended each county board of elections to have to look with a microscope of whether something was done exactly by 5 or not in these very high stakes situations. I think that was why the language is put in there that we need to look for substantial compliance.
that's a really,
I totally disagree with your contention, because then you're saying, what do we say means substantial? Is it 1 minute after 5? Is it 5 minutes after 5? And that's why it's specific.
Well,
I'm,
the board is given a certain amount of judgment, but I think it would be within anyone's judgment to say that if something is within 1 minute of the deadline, that it's substantially compliant.
So I guess the question is, do we have to take some position and say we're going to refer it back to the state and let the state make the decision? I mean, I'm not sure what action we're supposed to be
Okay,
taking.
I'd like to make a motion.
I would just answer his question real quick. Yes, you can, you can decide what you want to. You've heard from me, you've heard from him. You can either recess and wait to hear back from Paul Cox, the general counsel for the state board. And trust me, I have been texting him while I'm sitting here. You can decide on your own based on everything you've heard and considered tonight, that it was not timely and it will be deferred to the state board. Or you can say it was timely. I think that's up to you. You've heard my opinion and you've heard his opinion. And I think those are your options. I'm happy to do either way. If you did by chance want to recess, I would say recess it until tomorrow at a particular time. But if you wanted to move forward either way, that's up to you as well.
I'd like to make a motion that we determine that the protest filed to the Moore County Board of Elections was not timely.
Is there a second?
I'll second that.
All right, is there any discussion? Yes. Is there any discussion? Tony, you had a question, a point to make a little bit earlier. And I don't want to cut you off.
It's okay, I'll move on.
Okay.
Because it's been said, and it's over. This was just piggybacking on what Holly had said. I was taken aback by what you said. I don't agree with what you said about us not making that decision about 501 and the substantial thing. That doesn't count. It does. Because anytime you submit something at a particular time, if you're not there, you can't. They will just not accept that particular item, whether it be your ballot, whether it be your affidavit, whether it be your lawsuit. It does not get counted. And that's just clear thinking to me. 501 is 501. That's when we received it.
So I have a follow-on before we take the vote, that if the state agrees with us, then there will be no evidentiary hearing in Moore County, correct?
Yes, that's correct. The state board it gets deferred to the state board if you all make a determination that it's not timely. And further, it says if it's not timely, you cannot hear the protest hearing. That's in the law, and that's also in the FAQ that the state board sent out to all the counties to follow. So the state board will take this matter up.
I'll guess some of this is a reiteration of what we've heard before, but I think at least one point is at least just kind of a confirmation based on Mr. Taylor's email, and which is easier for me to comprehend on the printout because I can see the whole thing at once. That is, I think, Mr. Taylor, your notion of, it's close enough is a commonsensical approach, but I think that we've been asked throughout this process and in the filing from Mr. Griffin and his legal team to be very, very precise about following the general statutes to a T and how we address this protest. And by the same token, I think we're asking the protester to be county by county as precise as what's required in the general statutes. I also believe that, again, in concurrence with what Ms. Leland said, the reason that preliminary consideration is broken down into a sequence of steps is because each one of those criteria has to be met before we can proceed on to the next one. And the first one was the protest filed timely. Say it one more time, and this is the last one. Doesn't have anything to do with substantial, not really, really close, but is it timely according to the statutes, which is 5 o'clock on the second business day after that. And my understanding now, that last thing, looking at this, I believe confirms my earlier supposition that the email that's on Mr. Taylor's phone is one that was sent by the North Carolina Republican Party legal team to, and I think board. I'd love to know what's underneath the hood for that email address. And C shower is also in the to line. So board could be a placeholder for all of the boards that in North Carolina that eventually will be sent. In some instances, it could have been for those other counties. It could have been, or in fact, had to be well before 5 o'clock in order for them to have received that, as Ms. Dixon says that they have. At this point, the email that was sent to the board and C shower was sent perhaps. No, I'll say that according to their computer, it was sent at 4:59. I will concede that. On the other hand, the email that we have printed in Ms. Dixon's paperwork is to the Board of Elections in Ward County that's CC'd to Sea Shower. And that is labeled as sent at 5:01:06 p.m., which says to me it's not timely filed. That's as far as, I believe that's as far as we can go. Does anybody, or is there any further discussion or responses from Mr. Taylor or Ms. Leland?
No.
Okay, in that case, we'll have a vote. If you are in favor of Ms. Powell's motion that we could, I'm sorry, Holly, could you say it one more time?
That we make a determination the protest was not filed in a timely manner.
Is it just, okay, and there, do you want to add in your motion and therefore that we,
Well, that's all we have to decide.
okay,
And it will be automatically deferred to the state.
right, so we don't have to include that in the motion. All right, thanks very much. There's the motion. All in favor, please say aye.
Aye. Now, I have another question. Okay, so we've said that now. If the state comes back and says, we're going to assume it was timely because it met the substantial requirement. Tonight was supposed to be a preliminary hearing, correct? Not the actual evidentiary hearing.
I want
That's
to say
right.
it's preliminary consideration. They're very careful about how to call, what they call it.
Preliminary consideration, and the second step would have been the evidentiary, where Tawana or the statute has a specific way of describing who could speak, but it's quasi judicial in nature. She could introduce evidence that is her substantially impacted, could introduce some evidence into the matter for you all. But that's not allowed here. She can't introduce any evidence at this hearing. The state board gave guidance that if it's not timely, and Judge Griffin or whoever, in our case, Judge Griffin's,
Well, here's my question.
that will allow the person to speak, which I think we have allowed this person to speak and have an opportunity to be heard. He did say at one point that, we should have a hearing to give people an opportunity to be heard, but that's not what this hearing's about at all. So
Is there something we were supposed to have done as part of this preliminary hearing in order to go to the next stage, which is an evidentiary hearing? I'm still trying to figure out the purpose of the preliminary hearing, because basically,
We were supposed to do all this.
well, but as I've looked through, we have to, had we said that it was timely, we could not say we didn't want to go to an evidentiary hearing. We had to go to the evidentiary hearing. That
No,
was-
you don't have to do the rest of
There's
the
a
question.
series of steps
no.
that would have to be.
Oh, I was looking at some other stuff earlier that said we had to go to the, we would have to go to that. I just want to know, is there something we're supposed to do tonight in case they decide they want a hearing? Otherwise, do we need another preliminary hearing to do business in order to have the evidentiary hearing?
No,
Because if we
sir.
recess now and they come back and say, oh, no, you're going to have the hearing, well, what were we supposed to have done tonight in order to have the evidentiary hearing? Because obviously, if you're having a preliminary, you're supposed to do something in order to get ready and proceed to the evidentiary hearing, and I'm still unclear what it is.
I'm going to answer you. I want to come back so we won't forget. I do want you to make one more motion, just out of an abundance of caution. A separate motion to defer. It says specifically refer this matter to the state board. Let's just make that motion just in case that you are referring this matter that was not timely filed to the state board. Just an extra precautionary. Can somebody make that motion?
Thank you. There's a motion of that.
I'll make the motion that we defer to the state on this.
Is there a second?
Second.
Is there any discussion of this motion? Hearing none, all those in favor, please say aye.
Aye.
Aye, passed unanimously.
So let me answer Mr. Carpenter's question. So tonight, we were supposed to, you as a board, as the local board, were supposed to have this preliminary hearing. And I don't know if you have this, but you're welcome to take mine. On page 6 of North Carolina's election protest procedures guideline, it spells out what you're supposed to do. They've summarized everything nicely. But the hearing was to determine if the protest, person by person, if there was probable cause established. And the probable cause standard they have provided is the material submitted by the protester sufficient for a reasonable and prudent person to believe that the apparent result of the election was swayed by election law violations, irregularity, or misconduct. It does not mean that such a belief is necessarily correct or more likely true than false. A probability of an outcome determined of irregularity is sufficient. So that is where that substantial compliance comes into play, in my opinion, that we were talking about earlier. But part of the consideration to get here is that you have to determine if the protests were filed timely. That's both statutory and in the North Carolina Administrative Code, also in the written guidance provided by the State Board of Elections. It specifically states that if the protests were not timely filed, that we cannot proceed with the hearing, and it must be referred to the State Board.
Can we just do
Well, we'll hear. Any other questions? Clarification? All right. And as if I am understanding or reading accurately the agenda, I don't see any other matters. Nevertheless, Ms. Dixon, is there anything else that you would like to bring up this evening?
Yes, sir.
Well, I guess I'm back to my other question. Do we continue with what's on the agenda and answer these questions just in case? Otherwise, do we have to have another preliminary?
No,
You cannot, because it states that you cannot proceed with this hearing because it was not, the protests were not timely filed here in Moore County. You cannot do anything else.
No, I don't know what I'm saying. Okay, then, so basically, if they come back and tell us that we have to, they want us to proceed, that they consider it timely at the state level, what do we do then?
If they happen to do that, I suspect they won't, but if they do, then we'll have to have the hearing.
Evidentiary or another preliminary, since we didn't really answer the questions in the
We
preliminary?
would have to have a preliminary hearing.
That's what I was afraid of.
But I don't think that's going to happen at all. Because it specifically states from the state board and the law that if it's not timely, you cannot proceed with the hearing. You cannot proceed. So we cannot proceed with it. What else can we do?
I understand. I'm just looking at the worst case scenario. If the worst case scenario, in terms of how we're looking at this, they say, no, we're going to go along with that and say that it was substantially timely. Then we have to have another preliminary in order to answer these questions before we go to an evidentiary.
You might be able to do a preliminary hearing and then immediately do an evidentiary.
Which, my question is, why couldn't
No,
we have
sir.
done that to begin
We
with?
cannot. It needs to be noticed 3
You
days
cannot
in advance.
A preliminary and immediately do an evidentiary just because there is a notice requirement, but there is a short turnaround time. And, you know, if I know the state board and their staff have their hands full, but I do wish in cases like this that they would have responded back to Tawana when she originally reached out last week. But they didn't. And I think the law was clear in my opinion. But in any case, it is what it is, and it came in late. The statute's specific and the administrative code's specific. So I don't know what else we can do. But again, we were totally prepared, and Tawana was totally prepared to move forward. Obviously, what else can we do? We have to end this so you can make a motion to adjourn.
Is there a motion to adjourn?
I make a motion to adjourn.
Is there a second?
I second it.
All in favor, say aye.
Aye.
Aye. We are adjourned. Thank you very much, ladies and gentlemen.
I was to decide.
Could we-
You know, we're in-
Wait.